So Donald Trump and his DOJ tried to set a trap or call the bluff or just set up in general these federal judges regarding the release of the Epstein grand jury transcripts. And these judges, there's one in the Southern District of Florida, one in the Southern District of New York, and we'll see if another judge does this as well. But they've been seeing right through what Trump's plan was. And so when Trump tried to call their bluff by saying release the grand jury transcripts, thinking that these judges would say no, the judges responded, well, we'll consider it. Then they eventually said yes, but they said, tell us what you're turning over. We'd like to understand so we can better make our decision. Talk to us about every category of document that the Trump regime is turning over. So these judges saw the plan, basically called it out in real time without saying, oh, you're trying to set us up. And then they said, actually, we want to hear from the DOJ. Write us a letter and we want to hear about all the categories that you're going to be producing, because at the end of the day, we don't want you to let down or manipulate the actual victims or survivors of Epstein here by making them believe that the grand jury transcripts contain anything significant, because you at the DOJ actually hold all of these significant documents out there, and the grand jury transcripts, it's just like 80 pages, like a very short document transcript where one single FBI agent testified as it relates to like Ghislaine, for example. And it was, literally just, short, went through everything that was already known publicly from the criminal complaint and the true bill when the indictment was ultimately made public and unsealed, and what we know from Ghislaine's trial. The grand jury transcript doesn't add any new information. In fact, it's a much less than what we even learned from the trial, because it just relates to the criminal conduct for which there was this unsealed indictment. And so the federal judge says, this judge by the name of Judge Engelmeyer from the Southern District of New York said, list for me all of the categories of what you're going to produce. Then I'll tell you what I'm going to produce. But you tell me first. It was a brilliant move. And I'll tell you what he got the Trump regime to admit. But what Judge Engelmeyer also said was, I'm also very disappointed at the way the Trump regime has dealt with the survivors, or the victims, but we call them survivors here because that's what they really are, of Epstein. And here's what the judge says. The victims' concerns regrettably have a basis in fact. In its 2 rounds of applications to this court to disclose records, the Department of Justice, although paying lip service to Maxwell's and Epstein's victims, has not treated them with the solicitude they deserve. DOJ made its July 18, 2025 motions to unseal the grand jury materials in this case and Epstein's without giving notice to Maxwell's and Epstein's victims. Only after this court and Judge Berman in Epstein's case, that's the other federal judge from the Southern District of New York who I mentioned, inquired on this point and sua sponte, it's Latin, on their own, set a schedule for victims' input on the motion, meaning that the Trump regime didn't even ask for victims' input. The court had to do it sua sponte on its own. Directly or through counsel, give such notice. That's the only time that the DOJ even cared about the victims, when the court forced them. The letters the court thereupon received from victims widely expressed distress at the lack of notice given to them by the DOJ and alarm that the grand jury records DOJ would release, if authorized to do so, would invade their privacy. And as the court chronicled in denying the DOJ's motion, the motion itself misled victims and the public at large in holding out the Maxwell grand jury materials as essential to the goal of transparency to the American public, when in fact the grand jury materials would not add to public knowledge. Let me just repeat that one more time, that the court has chronicled how Trump and Bondi and their DOJ misled the public that what would be in the grand jury transcripts was something of significance, when it would actually add nothing to the public knowledge, because after the grand jury, there was a case of Ghislaine Maxwell, and the same stuff was discussed in the case, and all of that is public record. And the court made clear back in July that the DOJ held all of the records and the documents and the FBI interviews and the surveillance footage and the emails and all of the communications, the terabytes of data that we know as the Epstein files, was always in the DOJ's possession. And regardless of there being the Epstein transparency law, the DOJ could have always released it under Donald Trump's order, which they've still refused to do. Now it's due in about 7 or so days based on the Epstein transparency law. We already talked about how we believe the Trump regime is going to try to make objections and block it and claim that the information's part of an investigation. And this is why we suspect they're not going to ultimately release it. But here, Judge Engelmeyer, the federal judge that I'm talking about now, who wrote that, and by the way, a federal judge in the Southern District of Florida. We'll see what Judge Berman, ultimately does. But they've said, okay, based on the Epstein transparency law, fine. We'll release ours, but we want you to release yours too. So tell us what you've got. So this grand jury transcript, that's like 80 pages, that doesn't add anything new. The court's like, fine, we will analyze this law as trumping, pun or no pun intended, the grand jury secrecy issues, which usually say courts cannot release this material under Federal Rule of Criminal Procedure 6. It's sacrosanct, it's private, we don't release it, but there's a federal law now. But what are you going to release? So then Judge Engelmeyer gets the DOJ to say, okay, we're going to release financial records, travel records, grand jury subpoenas, records obtained from various government agencies in the Virgin Islands, school records, search warrant returns, materials produced by law firms, including firms representing victims, arrest reports, booking records, materials from related civil litigation, photographs and videos of relevant properties and locations, immigration records, records related to online purchases from various online retailers, materials obtained from the Palm Beach Police Department, forensic examination reports of extractions from the media, copies of photographs and others voluntarily produced by third parties, postal and courier records, materials produced by the Epstein estate, driver's license and DMV records, reports and notes of interviews of third parties and victims, and certain communications relating to the same. Although these certain communications may be doing a little bit more work there than it needs to. What's that ultimately going to be? Let's bring in Harry Litman from the Talking Feds YouTube channel, Talking Feds podcast, and Talking Feds Substack. One thing I noted as well there too is that the DOJ was pretending that it didn't have access to the Epstein estate documents. And they're like, well, we couldn't produce it. They never told us about it. Well, we know they've been sitting on it the whole time just from this. But I think what Judge Engelmeyer did here was he realized that this was a setup. He saw what was happening. And then he said, well, I'll produce the grand jury. Fine. I'll construe the new law that was passed. But tell me what you're doing as well. I think it was a brilliant ruling. What do you make of it, Harry?
Yeah, he's a thoughtful, meticulous, and I would say clever in the best sense of the word, judge. I've known him forever. But look, we got to remember this was from the start a ham-handed gambit by the Department of Justice for two reasons. First, this was to take some of the political pressure off when everyone was screaming for transparency and accountability, and the department was still in the mode of don't release it. So this was complete bogus idea. Oh, we're for accountability too. Let's release these grand jury records. It was bogus for two reasons. The first is they had to know, and they did know that, and Judge Engelmeyer and others, they would turn them down because guess what? It's the only reason they could come up with for releasing it is public interest. And that is, to say the least, no reason to unseal grand jury records. If it were, you would never have high profile prosecutions. But more than that, and this is what still matters, there never, ever was going to be important information of the sort for which the public is clamoring in either of these grand jury files. We have two, by the way. First is the real extremely sort of powder puff treatment in Florida in 2006 or whenever it was, involving a few state court charges and the then U.S. attorney letting Epstein have a ridiculous sweetheart deal. But the evidence there was not what was very sort of constrained. And then the 2019 prosecution, that's what Engelmeyer is looking at. There is both Ghislaine Maxwell, who went to trial, convicted, and now her conviction's final, and the Judge Berman, who had the Epstein prosecution. Of course, that stopped because Epstein committed suicide before it went to trial. But as you say, any smart prosecutor, and boy, do we have one here, right? Marlene Comey, the daughter of Jim Comey, who was fired simply for her last name. You're exactly right. You put in just enough to get the grand jury to find probable cause and not produce the sort of record. Eventually, grand jury materials can be ordered produced to the defense. And, the more voluminous they are, the more kind of grist for the mill of a rough cross-examination and the like. But the biggest point here is you read the indictment, the one that, in fact, Maxwell was convicted on. It's got nothing to do with what everyone wants to know now. It's not the victims. It's not the other customers, as it were. Even the sexual activity that's in there is by Epstein himself grooming the underage girls with massages and the like. It is the conspiracy, the agreement between him and Maxwell, period, full stop, with a couple little factual developments that serve as the so-called overt action that you needed in conspiracy. So it really is, and this was purposeful on Comey's part, the AUSA, narrow, circumscribed, and what Maxwell was convicted of. I mean, she's doing 20 years. It was serious enough. What is it not? It's not, and it hardly overlaps a bit with the 100,000 pages of 100,000 documents and 300,000 pages that the DOJ is sitting on. All the 302s, that is FBI reports of victims, possibly of customers, all the allegations. That's what people want to know. What's the scope of Epstein's crimes? Whom did it draw in? Whom did it victimize? And this grand jury material, which, by the way, you just to make it clear, at first the judges, like Engelmeyer said, I can't release it. But then the Epstein Transparency Act passed, and Congress had countermanded Rule 6. They said, now you have to let it out. And he is, with this very clever kind of first step with DOJ that you have described, Ben. But it is not, and it never was going to be, the material that the country is clamoring for. Nevertheless, I think it's significant. I'm eager to see it. And I think the person that it most hurts is going to be Ghislaine Maxwell, who has been, you referred to Todd Blanche's going down there without the documents from the Epstein estate. He went down with no documents at all. And he's trying to participate in a kind of whitewashing of Maxwell, possibly even a pardon. I think what you'll see is her culpability for the conspiracy itself will be really strong and stitched up in that prosecution. That's going to put the lie to her efforts of, just a social friend and nobody did anything wrong. But the actual motherlode of information, this is the important bottom line point to keep in mind, is exactly as you say, back in the catacombs of the FBI and DOJ. That's what they're being ordered to turn over. We will see how they try to resist it, maybe with like phony baloney intercessions like, there's now this investigation that Donald Trump ordered. But all this grand jury stuff, which is coming out, will be interesting for a lot of reasons, but not the reasons that everybody wants to get to the bottom of all the victimization that Epstein and Maxwell perpetrated on the underage victims.
Yeah, I mean, Ghislaine probably knows at this point, I got what I want. I'm at the minimum security facility. I'm getting VIP treatment here. It's better than what I had in Tallahassee. Yes, I looked like a fool, but, at this point, Donald Trump's out there pardoning the top narco drug traffickers and, the top Ponzi schemers, and Trump's giving away our top semiconductor chips to China on the same day the DOJ is prosecuting people for giving those chips to China. So, I mean, I think at this point, under this Trump regime, even the fact that we know that she committed perjury again, and that she lied, and that she covered up, and that she was disgusting. For her, it's like, I delivered for Donald. He'll give me that commutation or pardon at the end of his term. Now I'm just going to shut up. I'm not going to say anything else. I'll live out the rest of my days in Texas. And, and that's it. That's her play, and we, the people, can be like, cool, or we can resist that and say that's horrendous. And that's part of a cover up of a child sex trafficking ring. And the fact that it's being done right in front of our faces, so obviously, is beyond offensive and revolting. Everybody hit subscribe to Harry Litman's YouTube channel. It's called Talking Fed. So just
very quick point, Ben, to say, though, we have a real interest, as you say, in knowing the facts. And Maxwell's conviction is now final. It's all over. There's nothing to consider, although she's brought a collateral attack. She, I think, wants to stay in her relatively nicer prison, but she's going to be, I think, that Congress is going to want to hear from her, and she's already said it's very tenuous, but I'm going to invoke the Fifth Amendment, even though what criminal liability? You've already had your criminal case settled. So, as always with the Trump administration, the secondary follow-up really imperative of finding out what the hell happened. We're being frustrated right and left. And in particular, she's going to try to keep from giving the facts. They may wind up giving her immunity. That's not a commutation, not for her old crimes, but going forward and forcing her to talk. We'll see if she tells the truth at that point, because you could get into hot water for perjury. Of course, all of these would be dependent on a decision by this attorney general to bring charges. And, we know that that's a very remote prospect, given that her first instinct is what's in the political interest of Donald Trump.
Again, subscribe to Harry Litman's YouTube channel. It's called Talking Fed. Search it right now. Thanks, Harry, and hit subscribe to our channel as well.
Hey, thanks, Ben.
Want to stay plugged in? Become a subscriber to our Substack at MeidasPlus.com. You'll get daily recaps from Ron Filipkowski, ad-free episodes of our podcast, and more exclusive content only available at MeidasPlus.com.